Paul Guertin, a 40-year-old Foreign Service officer and resident of Arizona, was indicted on March 29, 2021 by a federal grand jury in Washington, D.C. He was indicted for wire fraud and obstruction of an official proceeding. Guertin had served in various diplomatic roles, including postings in China and Pakistan. As part of his employment, he was required to maintain a top-secret security clearance. According to the indictment, Guertin intentionally concealed critical information on his background check and in interviews with investigators. He concealed a sexual relationship with a Chinese national whose visa application he adjudicated, gambling debts, and a $225,000 loan from two Chinese nationals, including $45,000 in cash. The government argued that Guertin committed wire fraud by lying to obtain a renewed security clearance, which was essential for his job. The district court dismissed the indictment, but the government is appealing, arguing Guertin's deception met the legal standard for wire fraud. Let's take a look.
Thank you, Your Honor. Good morning, and may it please the court, Dan Lenners of the United States. If I might request 4 minutes for rebuttal. The indictment in this case properly charged a scheme to defraud for the purpose of obtaining money or property. When faced with the decision whether to renew Guertin's top secret security clearance, the State Department was faced with a concrete binary decision that went to an essential job qualification. If Guertin obtained a renewed security clearance, he would be employed in the future and would obtain those future salary payments. Were he not to obtain the renewed security clearance, he would lose his job. This case is thus like those in which employers make the decision to hire someone, to give them a bonus, to give them a promotion, to enter into a contract. There is a discrete, predetermined decision point that the State Department was faced with here. And Guertin lied to secure that renewed top secret security clearance, and thus to obtain the future salary payments that would come with his employment in the future. The district court erred by, in this case, characterizing this as a mere salary maintenance theory of liability. This is not a case where an employee engaged in sort of routine day-to-day lies that go to ephemeral job characteristics such as productivity or wasting time on the internet. Instead, the need to have a top secret security clearance was an essential job qualification. It was a binary decision whether to renew it or to deny that renewal. And were that renewal denied, Guertin would have eventually been found.
So in the situation of wasting time on the internet, which since you raised it, that's the hypothetical that's used at the Yates case, as you know. And the supposition on the part of the Ninth Circuit is that if your theory is correct, then that person would be guilty of wire fraud because they would have violated, and we can definitely manufacture the specific rule if we construct the hypo in the right way, that bars the use of the internet for personal business on the work premises. And we can make that a binary requirement too. And it's just an on-off switch, and somebody lies about that. And does your theory mean that that person has committed wire fraud with the relating to the obtaining of a future salary stream, continuation of their current payments?
I think the answer is yes, if I understand the hypothetical correctly, which is part of what's key here to the government's theory of wire fraud is that there is a discrete decision that the State Department was faced with. Mm-hmm. That it was a binary decision whether to fire him or deny his security clearance or re-up it and allow him to be employed in the future, and that this was set in advance. That it was part of not just a general review of the employee's productivity, as in the Yates case, but instead was something that Guertin knew about, and in fact he knew that if he would lose his security clearance, he would lose his job. And so the court need not decide sort of the broader issue as to whether any future salary would.
It seems to me that you're basing a lot of your argument on the notion that this is a discrete binary condition. And I guess my question is, it seems like we could make basically everything in the workplace a discrete binary condition, as long as you have an employee manual that's given to you on day one that spells out, here's the various discrete binary things that you can or can't do. One of which, in a list of 500, is you can't use the internet at work for personal business. Just can't. And so everybody knows if they read the 500 discrete binary requirements that that's one of them. And I take it that if that is spelled out in the employee manual that you read on the first day you show up at work, that the violation of that can be the gravamen of a wire fraud prosecution.
If the other elements of wire fraud are met, which I think also protect.
Is there a reason not to think that those won't be met?
Well, here the employee has to have an intent to defraud, so a specific intent to defraud the company. The lie has to be material. So material to obtaining those future salary payments, meaning material to keeping the employee's job. There has to be some sort of certification of, it's a lie. There has to be a knowing and intentional lie. And so I think that.
And why do any of those seem like much of a limiting principle? Because if the employer spells that out in the employee manual, presumably the employer thinks it's important. And let's just suppose the employer does. They check, every month, just making sure that you haven't breached any of the 100 discrete binary preconditions that I itemized in the employee manual I gave you. You showed up, and it turns out that there was a lie with respect to one of them. And of course, the employee knows that if I lie, I could be fired because I've been told that when I got the employee manual. I'm not saying this necessarily means that your theory can't win, but I'm just wondering about the implications, because in your briefing, you sought to distinguish the hypo in Yates about the person who is on the job and uses the internet for personal business. It just doesn't seem like that's really very much out of bounds to me, because it seems like that can very much be in bounds as long as the employer does the thing where they give the employee manual that shows that that's a requirement they really care about.
Well, I think as a practical matter, the requirement that the employer really cares about limits these situations. It would be unwieldy as a real matter of realism to list 100 binary items and check them every month. But also important to Your Honor's hypotheticals, it's not just that the employee knows he could be fired. To have the specific intent to defraud and for the lie to be material to obtain future salary payments, I think it has to be a higher standard. The employee has to know he's going to lose his job. Or it certainly Guertin met that here.
No, it has to know that they could lose their job. I don't think the government. Do you think the government has to show that they know that they would lose their job?
It makes it harder to prove that the purpose of the lie was to obtain future salary payments if the person only knows they could lose their job, because then it may not be material to the employer's decision. The defendant may be able to argue that the lie wasn't for purposes of obtaining salary they weren't otherwise entitled to. And so I'm not sure that the government has to prove it, but it certainly distinguishes this case from the hypothetical Your Honor has given. And I think some of these limiting principles go to the concerns for the honest services fraud and void for vagueness and sort of criminalizing common workplace misconduct. This top secret security clearance process is none of those things. It is spelled out in advance. Guertin was well aware of it. Employees are warned that if they lie during the process, it's prosecutable as a crime. And it's an essential job qualification for a foreign service officer to maintain a top secret security clearance. And so even if there could be a broader theory of wire fraud that would be actionable, it seems like this much more narrow theory is actionable, and the district court erred by finding it.
How about a still narrower one? Because by narrower, you mean a discrete binary condition that the employee knows about. That's what you mean?
Yes, sir.
And how about a still narrower one, which is that it's a discrete binary condition that the employee knows about and that was also imposed as a condition of getting the job in the first place. So it wouldn't apply to things that only occur on the work premises, which could sweep in all kinds of stuff that's dishonesty in some measure in the workplace, which is what the Supreme Court appeared concerned about in the Skilling case. But it's the conditions that are imposed as a prerequisite to getting the job in the first place, which everybody agrees is the possible subject of a wire fraud prosecution, that are then carried over and repeated when you're on the job also.
That's certainly true here. That exists here. How to reconcile that with the plain language of the wire fraud statute is not something I've thought about. It fits in the contracting. It also fits in the contracting cases where a contractor has to certify, say, that they have sufficient disadvantaged business subcontractors, and then has to recertify that throughout the course of it. Both are for the purposes of obtaining the future benefits of the contract or the future benefits of the
Sounds like maintaining.
But I disagree that it's maintaining because
Once I have it, I know there's certain things I have to do to maintain.
Because the employer has a choice to make that it doesn't have in the run-of-the-mill employee contract. It has a time to make it. It has this decision whether to renew the security clearance or not. And that is a preset decision that the employee knows about. And so in that case, this is sort of conceptually, I think, the same as obtaining the job in the first place, obtaining the promotion, obtaining the bonus, as opposed to just sort of staying employed while frittering away time.
Mr. Lenners, looking at the text of the wire fraud statute, the Supreme Court in Kelly said that although the first two parts are disjunctive, you need to read money or property into a scheme to defraud. But what about the word obtain? Do you have to read obtain also into the first disjunctive part of the wire fraud statute? Does Kelly require reading the word obtain into the first part?
I certainly have assumed it does. And I have assumed that went back to McNally. I could be wrong, but the Supreme Court, as I understand McNally, even predating Kelly, said that a scheme to defraud that was not to get money or property is not properly chargeable. That's just honest services fraud. And that looking back at the history of the fraud statutes and the common law understanding of fraud, that the fraud had to be to get something, whether it be money or property.
Getting in some general sense doesn't go to the distinction that's at issue in this case between maintaining and obtaining, arguably, because nothing turned on that distinction in either McNally or Kelly, perhaps.
I mean, I think that's right that McNally and Kelly did not address the specific question at issue here. To the degree that the question is whether future salary is money or property, the Supreme Court said, I don't remember the name of the case, but it reads property broadly, and it should read money broadly as well. That there shouldn't be a limiting principle there. And so, to the degree there's any question about whether these future salary payments are obtaining money, you would think that the Supreme Court would read that broadly. The narrowing principle meaning being that the scheme to defraud has to relate to money or property as opposed to some other thing.
I'm not sure the government can benefit from any distinction that I just drew here because the indictment alleges it was obtaining money or property. But I was wondering if it is the government's view that there can be a scheme to defraud for money or property that does not involve obtaining the money or property. Some other verb, perhaps. I'm not sure what that would be. I guess what I'm saying is that it's possible that under the first disjunctive part of the wire fraud statute, you could have a scheme to defraud for maintaining money or property. Maybe. I'm not sure under Kelly and McNally.
I don't know the answer to that, Your Honor. Certainly the honest services fraud statute 1346 means that the charged defendant doesn't have to obtain money or property. Generally speaking, a bribery or a kickback scheme is to obtain money or property, but you could imagine a person who is being bribed with something different, services of sexual nature or something like that. And that's still a bribery scheme that would be chargeable under the wire fraud statute. We focus much more narrowly on the fact that this scheme isn't just for maintaining anything. It is for obtaining. So regardless of whether other verbs might fit, it comfortably fits within the meaning of obtaining, because without a renewed top secret security clearance, Guertin is going to lose his job and his salary.
We'll give you some time for rebuttal.
Thank
Mr.
you.
Myers. Thank you. Mr. Pete?
May it please the court, Matthew Pete on behalf of Mr. Guertin. As the court's questions illuminated, there really is no limiting principle to the concrete binary claim by the government, other than the one suggested of something that has to be at the moment of hiring. I think what Yates points to is that when it talks about a specific performance metric, it's talking about something tied to compensation. And I think that is a true limiting principle that ties misconduct or dishonesty to money or property under the wire fraud statute. If there's a performance metric tied to compensation, like a bonus, a raise, or a promotion, then the government has legs to stand on. But without that, you're left with simply nothing that's being obtained by that dishonesty, just maintaining an employment status.
I have to say, I don't understand the supposed continental divide between obtaining and maintaining. It just seems to me to be entirely fine to say, I'm maintaining my ability to obtain my future payments. It's both. You're maintaining the payments that you've gotten to date, but that's not to the entire exclusion of also saying, I'm trying to obtain the future payments that I haven't yet gotten.
Well, I would point the court to the language in McNally in the dissent. It talked about salary as something that is always there being offered to the employee, that the employer is losing out on. And of course, that theory didn't carry the court. So there's a notion of salary inherent that's been discussed by the Supreme Court and inherent in the context of the wire fraud statute.
But it wasn't an issue in McNally because McNally was that was about whether you've been deprived of the honest services, not whether you've been deprived of a future stream of income.
Correct, Your Honor, but the point of the dissent was the employer is not getting what the employer bargained for, not getting what the employer is paying for. What they're paying is salary. And so I think that fact that salary is a concept in the context of the wire fraud means there is a distinction between obtaining a position, which comes with a salary, and maintaining that position, because the salary has been obtained. The salary is going to continue to flow.
Yeah, it hasn't. What's been obtained, you don't have an entitlement, contractual or otherwise, to the future payments. I mean, you can manufacture a situation in which you do, but as a general matter, you might have an expectation that as long as I'm not fired, I'm going to continue to get the same payments that I've gotten let's just say it's monthly, make it easy. I'm going to continue to get the same payment in future months as I've gotten in past months, as long as I don't get fired. But why can't the employer just construct the terms of employment like they generally are and like they presumably were here to say, yeah, here's your salary, and you'll continue to get that payment at the beginning of every month unless the following things happen. So you shouldn't assume that you're entitled to the future payments. You only get the future payments if the following things happen, including that you continue to have a security clearance. And then you have no expectation that you're going to get the future one. You always have to keep maintaining your security clearance so that you can obtain the future payments.
Well, as the district court pointed out, there's a kind of construction you can make with that, but it's somewhat torture. And so, of course, the court looked to precedent to understand the language, and the court looked to the dictionary to understand the term. And then the court looked to the rule of lenity, because it's a criminal case. And applying all three of those, the context of the Supreme Court cases, the dictionary definition of obtain versus maintain, and the rule of lenity, I think the district court was right to counsel against that kind of academic.
Just putting aside lenity for 1 second, and just focusing on dictionary definitions, I don't know that I understand what's definitionally difficult about this. If the terms of employment are that you're not entitled to next month's salary unless you have a good security clearance, you're just not entitled to it. You're told that from the very first day you show up at work. Yes, you can expect that you'll continue to get these payments, but you're not entitled to a future payment unless you maintain your security clearance in good standing. And then it seems totally natural in the English language to say, I'm hoping that I can obtain my next salary payment. And as long as I have a good security clearance, I will be able to obtain it. But if I don't, I won't.
Well, I think the difference here is that the employee is doing work for those salary payments. And so it's not just the employer setting the terms and saying, you got to do all this. The employee is doing the work that entitles them to the salary payments for the work performed. And the employer can say, well, these are my conditions, but the employee has done the work. And so the question, is it fraud? Is it obtaining that money or property by fraud when the employee is doing the work? And I think obtaining position is a moment of bargaining, and it may or may not be essential to the bargain, the dishonest statement that the employee made to get the position.
But it's doing the work with a security clearance. It's like having to come to a job with a certain uniform. It's not enough of a response to say, well, I brought the hammer. I don't have to wear all that other stuff. But you're not doing the work the way the employer wants it done. That is with security clearance. And if you come to work without a security clearance, it seems a shallow argument to say, well, I'm prepared to do everything else you wanted me to do.
Well, Mr. Guertin always had a security clearance when he did the work. And so this alleged scheme is that he was lying to keep his security clearance so that he could keep his job, so that he could then do his job, so that after doing his job, he would get his salary payments for that job.
But he shouldn't have had a security clearance. That's the employer's
That's what
problem.
the fight is about.
Right, but the alleged misrepresentations are about the 216 clearance process, which never completed. The allegations in the indictment, it's beyond any statute of limitations. Anything happened in 2010, and there's no allegation he got his security clearance improperly. So we're talking about someone who obtained a position and then started working that position with a security clearance.
Suppose you have to maintain good standing in the bar. Let's just shift to that. And then what the employee does, and let's just assume it's employee-employer relationship. And what the employee does is lie about whether they've maintained good standing because they actually lost their bar license, or they're not in good standing. And they do that just so they can continue to collect the payments. Under your theory, that would not be wire fraud, right?
Correct. I think
so. In that one, it's actually already happened. You're just not in good standing anymore, but you just lie about it. And
you have a position and you lie to keep the position.
Right.
Well, yeah. I think in that situation, you're lying to maintain something you've already obtained, and you didn't obtain it with a lie. You have it. Now you're lying to maintain it. And it's a very fine distinction, but it's one that
you're lying to obtain future payments to which you're not entitled unless you're in good standing. Because if you're not in good standing, you can't obtain those future.
I think it would depend on the nature of the payments and the nature of the job, whether it is something that is more akin to a promotion or to a new contract, or whether it's more akin to a contract you already have. You may start building a house that you obtained the contract to build the house when you had your license, and you get 2/3 of the way through and you lose your construction license, but you finish the house. And so the question is, did you obtain anything or maintain it?
Mr. P, does your argument in part turn on the nature of being a foreign service agent, being part of the civil service, where you're not exactly an employee at will? Does that matter?
It does matter, and I'm glad you brought that up, because there's an important issue that unfortunately doesn't help the court with the very academic question of maintain versus obtain, but I think is very important to disposing of this case. It is not true that we have conceded that Mr. Guertin would have lost his job had he lost his clearance, or more specifically, lost his access to his salary stream. The indictment is somewhat inconsistent with itself, because it does have a line saying it's a security clearance with a condition of employment, but it refers to the FAM regulation. And I would point the court to FAM regulation 12 FAM 236-2-2, which is in the statutory appendix. What it states is, losing your security clearance does not mean you lose your job or your salary stream because you're a civil servant. There's lots of protection. Obviously, there's a whole adjudicative process of whether you keep your clearance or not. That's not what I'm saying. What I'm saying is at the end of that process, even if you lose your clearance, it is a discretionary determination by the secretary whether there's some other position in which you could maintain that salary without affecting national security. For Mr. Guertin, there was. He'd already been offered that position. And so the government's entire theory of a concrete binary choice, that metric, that without which you cannot get that salary stream does not apply.
So the government can't terminate the employment of somebody who lies on their security clearance application to re-up their security clearance, to maintain their security clearance?
Well, whether they can terminate them for lying, of course they can terminate for lying. And they can terminate them.
Or they can't terminate them for not having the security clearance anymore.
Correct.
At all.
Well,
It's not that they have, it's not that, I mean, is the question whether it necessarily follows that they're terminated, or is the question whether the government has any ability to terminate them at all?
under the government's articulation of the limiting principle, it has to be the case that this is a requirement without which you will lose your job and your access to salary stream.
I guess why can't it just be a requirement without which you might lose your job? And that's why you try to show that you still satisfy the requirement, because you know you might lose your job. Now, it doesn't have to be that you'll automatically lose. It's just that you do it because you know that there's a reasonable likelihood. Does that not work?
I think it doesn't work for the reasons that we're coming to the court with from McNally and everything else that has forced the government into a position of articulating a standard to avoid saying any workplace dishonesty is actionable as wire fraud, which they recognize as serious due process concerns recognized by the Supreme Court. The government has said, okay, it has to be a binary, concrete metric that you would not have gotten the job without it, and you will lose the job without it.
Is that also true at the moment you get the job, so that the lack of a security clearance, does that automatically mean you can't get the job to begin with? Or does it just mean that that's a reason that the government can choose not to hire you?
You cannot get the job without a security clearance. And that is, again, another reason that obtaining and maintaining are different. You cannot get the job without the clearance. But once you have it, you have a whole set of new rights because now you're an employee.
Mm-hmm.
And those rights include the due process of keeping your security clearance or not. And then even if it's taken away, the right to have a job unless the secretary determines that you are a national security risk and decides to fire you. So it's discretionary and it's based on that particular determination. So there is even in the regulations, there's a difference between an applicant and an employee, and the government's theory depends on there being no difference between an applicant and an employee.
But your theory also would still apply even if there were no difference, right? Because your distinction between maintaining and obtaining would definitely cover the situation in which the very same thing is both a condition of obtaining the job to begin with and a condition of avoiding being fired.
Yes, and it has to be related to the bargain. You know, I think there's about 8 different pegs that I would argue we can win on, and the government has to win all of them. I would maintain if the interpretation is not essential to the bargain, it doesn't necessarily fall as an example of wire fraud. You know, you have the case of someone being lured into a bar to buy more expensive drinks. The luring itself didn't go to the bargain of the drink. You know, I think it's a close call whether someone has to be a citizen to obtain a position, and they lie about that. But it has nothing to do with the job requirement. You know, is that fraud, or is it just fireable and actionable under other statutes? But putting that aside, I do agree that my theory would work, or my explanation would work, if it is.
How much work, Mr. P, does the rule of lenity have to do here, in your view?
In my view, it doesn't have to do very much work because first you look at the dictionary definitions of obtain and maintain, as the district court did. And then you look at the context of Supreme Court decisions, which actually discuss in a relevant context in a way that anyone coming to the statute would understand what is prohibited and not in the same way as the dictionary. But I think if you can still get past those, the rule of lenity does play a role here. Because we're looking at the stretching of the criminal law in a context in which there's nothing that someone looking at it would know the way that it's going to be applied. So you think it does some work, but not. It's obviously the last resort. But I don't think it's that necessary.
If we thought the distinction between obtaining and maintaining is hard to really hang our hats on, then can the rule of lenity push in favor of affirmance here?
Absolutely. I mean, this is a criminal statute. Criminal statutes are always construed strictly because you're dealing with someone's liberty. So I do think it does enough work here to counsel in favor of it.
You wouldn't have as much uncertainty if the government's ability to carry out a prosecution in a case like this would only be seen, from our opinion in this case, to apply in a situation in which it's the same condition that was in place both as a prerequisite to obtaining the job to begin with and as a condition of keeping the job.
I think that is a useful limiting principle. But I think, especially here where there is a distinction between an applicant and an employee, and the regulations treat them differently. You have new rights as an employee, and that means that maintaining is still different than next. My time is up.
Okay, thank you, Mr. Pete.
Thank
Mr. Liners, we'll give you 3 minutes for rebuttal.
Thank you, Your Honor. There's just 2 points I'd like to briefly address. The first is certainty with which Guertin would be fired were he to lose his security clearance. That certainty is relevant to his intent to defraud and the materiality of his lies. So the intent to defraud has to be an attempt to obtain money or property he doesn't have. So he has to think he will be fired, and there's good reason to think he'll be fired because there is a presumption that a person who loses their security clearance will lose their job at the State Department unless the secretary, in his or her discretion, finds that another employment position is suitable. And so it doesn't ultimately matter if, as a matter of fact, he would be fired. It's whether he had the intent to defraud, meaning he thought he would be fired, and thus that's what drove his lies. As to the questions about the distinction between maintain and obtain and the work that the word obtain is doing, I think the clear statement from the Supreme Court on this is in McNally at page 358, where the court said that to defraud commonly refers to wronging one in his property rights by dishonest methods or schemes, and usually signify the deprivation of something of value by trick, deceit, chicane, or overreaching. They said the codification does not indicate that Congress was departing from this common understanding. Adding the second phrase, meaning obtain money or property, simply made it unmistakable that the statute reached false promises and misrepresentations as to the future, as well as other frauds involving money or property. And although not entirely clear, that saying that obtain money or property is simply a way of getting frauds that go to the future would seem to cover this circumstance exactly, which is Guertin's fraud went to obtaining his future salary.
Can I just ask you one question on the Ninth Circuit's opinion in Yates? So, as I understand it, your position is that we wouldn't have to disagree with Yates because this case involves a specific performance metric using the language of Yates. And
Yes, John.
Yates did not. And I guess the sentence in which that appears says, we agree that if an employer offers a raise or bonus tied to some specific performance metric, an employee who lies about having achieved that metric has deprived the employer of something of value. And I take it that the use of raise or bonus was an advertent one because that is obtaining something different from what you'd already been receiving before. So from that standpoint, the fact that this case, under your approach, involves a specific performance metric wouldn't be enough to distinguish Yates.
I'm not sure if that's right. Yates dealt with bank employees who lied to the board of directors about the bank's performance to keep their jobs, their standard salary, and their standard end-of-year bonuses. And so it's not clear to me that Yates would have come out the same way had there been a specific performance metric that the employees were lying about to obtain those future salary payments and those bonuses. So I don't know that Yates itself is clear as to whether it would come out differently if there was a specific performance metric as opposed to general lies about the bank's financial condition.
But the only sentence I think in Yates that uses specific performance metric, which is the language that you understandably latch onto, is one that ties it to a raise or a bonus. And it's just pretty stark that the formulation involves a raise or a bonus, given that a raise or a bonus would actually satisfy the opposing side's argument too, because that's something different from what was being received.
That's true. Your Honor, and if the court wants to say we disagree with Yates and Yates was wrongly decided, the government would agree with that. But
Right. I assume you would. Yeah.
But I don't think the court has to.
All right. Thank you, counsel. Thank you to both counsel. We'll take this case under submission. Mr. Peed, you were appointed by the court to represent the appellee in this matter, and the court thanks you for your assistance.
Case number 22-1142, Grayscale Investments LLC petitioner versus Securities and Exchange Commission. Mr. Burley for the petitioner, Ms. Dorisi for the respondent.
Good morning, counsel. Mr. Burley, please proceed when you're ready.
Good morning, and may it please the court. I'm Don Verrilli for petitioner Grayscale. This appeal challenges an SEC order disapproving an exchange's request to list an exchange-traded product that holds Bitcoin as its underlying asset. The fundamental problem with the order is that it contradicts previous SEC orders giving the green light to Bitcoin futures ETPs that pose the same risk of fraud and manipulation and have in place the same CME surveillance mechanism to protect against those risks as the spot Bitcoin ETP that the SEC disapproved here. That is the definition of arbitrary decision making, and it's worse than that because the decision actually disserves the policies set out in Section 6.5 of the Exchange Act. This is not your typical APA appeal. We are asking to be regulated in this way, not to hold regulation at bay. And regulating us in this way would better protect investors because it would give them the benefit of oversight by NYSE ARCA on the basis of the surveillance and sharing information from the CME. Disapproval leaves the investors in a situation in which trading will continue on an over-the-counter market that is largely unregulated, and therefore they are less protected. Beyond that, hardly serves the statutory goal of removing impediments to a free and open market to leave $4 billion in value locked up in this fund as a result of it not being ETP. And of course, disapproval discriminates between issuers of futures ETPs and issuers of spot ETPs, which also the statute prohibits. But I think it might be helpful if I take a minute at the outset to do a bit of a deeper dive on the contradiction between the two. And I think the place to start is with the language of the statute of 65. The statute provides that in order to approve an application, the SEC has to conclude that the rules of the exchange have in place measures designed to prevent fraudulent or manipulative activities. With respect to the spot ETP that's at issue here, the commission concluded that that standard wasn't met. But Bitcoin futures ETPs that the SEC approved are going to be affected by manipulation of the spot market. The SEC said that exact thing in the Supreme Order, and it stands to reason. Bitcoin futures are derivatives of Bitcoin itself, and the undisputed record evidence shows that 99.9% of the time, the price of Bitcoin futures and Bitcoin spot market and the Bitcoin spot market correlate. And what the SEC also found in the futures orders is that the existence of the surveillance sharing agreement would suffice to protect against fraud and manipulation of the spot market, as well as of other unregulated futures markets. And the reason for that is because the SEC concluded that manipulation of the spot market or manipulation of the other unregulated futures markets would show up in the price in the regulated futures market.
So how do we know that the Tukrium order, in making the statements that you just paraphrased, was specifically talking about manipulation of the spot market as opposed to manipulation of unregulated futures markets?
So I would direct the court to pages 21, 679 and 680 of 87 Fed Reg, which is the Supreme Order. I know the commission makes that argument in its brief here. The court can, of course, read for itself the relevant paragraphs on those pages. I think it's extremely hard to read them as not addressing spot as well as unregulated futures markets. If one looks at the preceding paragraph, there's a discussion, I think it comes up 5 or 6 times, the question of spot markets as well as unregulated futures markets. And then and then with respect to that, the exact phrase that we pointed to, where the commission says CME surveillance can reasonably be relied upon to capture the effects on CME futures markets, whether the attempt is made by directly trading on the CME Bitcoin futures market or by trading outside of the CME Bitcoin futures market. If I'm remembering correctly, I think the immediately preceding sentence is talking about. So, and I think that the SEC must have concluded that that was the case, because otherwise it couldn't have concluded that the statutory standard was met. The statutory standard requires that the design of the exchange rules is sufficient to prevent fraud or manipulation. And so it had to have concluded that the existence of the CME surveillance mechanism is going to pick up spot market manipulation insofar as it affected the futures prices. And that exact mechanism is operating now with respect to the relationship between NYSE ARCA and CME.
Mr. Ridley, the previous SEC denials of spot Bitcoin ETPs, were those challenged in court?
Yeah, I don't believe they were.
I couldn't find anything. So a lot of this really turns on the fact that the SEC has now decided to allow future Bitcoin futures ETPs, and the failure to treat the two similarly.
I think our case is quite a bit stronger, given not the fact of, but the reasoning behind the approval of the futures ETPs. Mm-hmm. I think even if the SEC had not done so, we'd probably be here making a similar argument that CME surveillance would work exactly the way that the SEC found that it would work in the Tukrium and Valkyrie orders. But you don't have to take our word for it, because they have made that finding in these orders.
I do wonder if we were to agree with you that the SEC has behaved arbitrarily and capriciously in treating these two products differently. Do you think the SEC will then have to approve the spot Bitcoin ETPs, or might the SEC simply reverse its determination about Bitcoin futures ETPs?
Right. We're asking for the standard remedy. We're asking that the order be set aside, which means we go back to the commission. And it seems to me they have 3 options available to them. First, they could agree with us that the prior reasoning really compels the conclusion that this also has to be proved, because the risks aren't any different, actually the same. The other option, I suppose, we did try to come up with some different distinction. I don't know. The third option would be to say, well, we got to rethink. Guess nothing would prevent them from doing that.
I assume you don't want the third
It would
thing.
surprise me if they would do it, though. I mean, they have, they have these futures ETPs that, because of the oddity of the statute, got through on the 40 Act. Have additional futures ETPs that the commission has approved under the 34 Act. They're out there trading. There's billions of dollars. The commission just made these decisions roughly instantaneous. Just a couple of months before ours. So presumably they were thinking about these things that change. As I said, it would surprise me a great deal if they decided to rethink the whole thing, but it's not, I don't see anything that forecloses.
Do you think that second route's available of the three that you just itemized, which is that they could come up with an explanation? Because I understood your argument to be almost one of an economic identity.
Well, I think that's why I said I can't come up with a, I mean, it's theoretically, it's not theoretically available, but I'm not sure what it would be if you take as a baseline the approval of a futures contract, because of that, the unrebutted record evidence showing 99.9% inflation movement, which of course stands to reason. And if I could just, I want to address one of the specific arguments the commission made in this regard, namely that, well, the futures markets are actually priced based on the spot prices. I will point out first, they said exactly, they rejected that exact argument in the order. But beyond that, just as a matter of common sense, on the day that a futures contract expires, you got to deliver. The price of what you have to deliver is the spot market value on that day. And Bitcoin futures are settled in cash. You don't actually deliver a Bitcoin, you settle it in cash. It's kind of a contract. So by definition, the spot market is dictating the price of the futures on the day of settlement. And so, of course, movements in the spot market before the day of settlement are going to affect the price of what people anticipate the value. Of course, it's just, I mean, they suggest the contrary, but I don't see it can do so. And I will say, with respect to the reasoning, as I read the order at least, the sum total of their reasoning as to why you can't make that assumption is in one sentence in footnote 233 of the order. Is where they say, we have shown correlation. The correlation doesn't prove causation. That's it. That's one unelaborated sentence. But I think the problem for them is that there is unrebutted expert analysis here, and I point the court to Professor Whaley's submission, his comments. He's an esteemed professor, expert in this area. He walked through the analysis of why it's not random. And of course, it's not random for the reason I just said. Of course, the prices are going to move together. So that one sentence seems to me doesn't come close to meeting the bar that they have to meet to demonstrate that this is a reasoned decision.
Mr. Burley, can you, one of the things that the SEC seems to really emphasize in its briefing is this idea that it's not focused on the potential for fraud, but only the regulatory detection of fraud.
Right.
What do you say to that argument?
So,
is that consistent with the statute?
it's a little bit hard, right? You took the words out of my mouth, Your Honor, in that the statute requires them before approving to find that the exchange has rules in place that are designed, I think design is the word in the statute, to prevent the fraudulent practices that would affect the product for which approval is sought. So in order to find that the statutory standard is met, which they did with respect to the futures ETPs, have to reach the conclusion that the surveillance sharing mechanism meets that requirement. And with respect to that, a couple of points I'd make if I could. First one is that what they concluded in the agreement with Valkyrie is just indisputable that there is a risk of fraud and manipulation on unregulated markets, futures markets, and unregulated spot markets could affect the price of the regulated CME Bitcoin. That risk is there. The sponsor of those funds came in and said, you don't have to worry about that risk. It's not there. The SEC said, oh, yes, it is there. It's there. And I said, but the CME surveillance agreement suffices to protect because it'll show up and then the information will be shared to the exchange in which the ETP is listed, and the exchange can use its enforcement mechanisms. That's the logic statement on those paragraphs that I cited previously in the truth report. Now here, and I do think this is fundamentally arbitrary, and it's not arbitrary in the sense of, the gotcha sense of here. It's fundamentally arbitrary In our case, they said, no, no, you don't meet our significant market test because you don't have an agreement with the market you don't have an agreement with the market that someone who wanted to manipulate the spot market would have to manipulate. That's what they said. That's really the core of our application. And again, I'm doing this a bit, but I think it's useful. Going back to the two-frame order, CME surveillance can reasonably be relied upon to capture the effects of on CME futures markets, whether the attempt is made by directly trading on the CME Bitcoin futures market or by trading outside of the CME Bitcoin futures market. Then they go on to say, accordingly, for present purposes, it is unnecessary for ARCA to establish a reasonable likelihood that the would-be manipulator would have to trade on the CME itself to manipulate the proposed fee. So they said that because of the surveillance agreement, that the sponsors of those futures ETPs didn't have to demonstrate the existence of an agreement with a market on which it's reasonably likely that would-be manipulator would have to trade and manipulate. And here, they insisted that we did. And so you just cannot put those two things. That I think is a core problem with their reason. Either they were right in two-frame, right here, can't be right in both situations. And that's why you can't defer to them. It just isn't a basis for deference here. Because you either have to defer to their expert judgment that the CME surveillance agreement would pick up the off-the fraud and regulated. Or you have to agree with them here that it wouldn't. You can't do both.
Has the SEC here waived a reliance on deference?
I didn't hear you.
Has the SEC here, do you think, waived its reliance on deference?
I think they make a gesture towards deference, Your Honor, but with respect, at least to the statutory interpretation question, and I just take I'm over my time, but if I may just take a minute on that, that they want to clarify what our statutory interpretation is. That the essence of our argument there is that what the statute says is that the statute says that the SEC shall approve an application that it finds meets the standard. So there's discretion there. It says it. But then what it has to find is that the design of the exchange's rules is sufficient to prevent fraudulent manipulation. That's what it has to find. Now, I suppose if the SEC has adopted this significant market test as a standard, I suppose if they apply it in the way that they applied it in the two-frame and Valkyrie orders, you could say it's consistent with the statute, because they said, well, CME surveillance actually works to pick up fraud and manipulation on regulated markets that affects the regulated market. And because of that mechanism, we're going to allow this forward. Our position is that it is inconsistent with the statute to interpret it and apply it in the way they apply it here, because they're saying that even though what they found in two-frame and Valkyrie, even though the CME surveillance pick up the spot market fraud and manipulation, and that information would be shared with the exchange, so it could use its enforcement the way that whole system is supposed to look. Even though that's true, we're not going to prove this. So even though the exchange does have rules designed to prevent fraud and manipulation, and they operate in precisely the way the SEC approved in two-frame and Valkyrie, we're still going to disagree. That's not just an arbitrary and capricious problem. It seems to us that's a problem of statutory.
But your arbitrary and capricious argument is the one that you front, and on that there's arbitrary discrimination. And as to that, there's not a question about deference to statutory interpretation. That's just a straight up.
Right, but I guess what I would say, deference to expertise. I don't see how you can defer to their expertise in the typical arbitrary and capricious review in the sense that their expert judgment in prior orders and expert judgment in disorder legal.
Right, but that's not Chevron deference. We're talking about arbitrary and capricious review.
So deference in respect to the user.
I have one, but I want to make sure that I have just one factual question, and it doesn't have to do with the issues that are directly before us, but just for our identification. So the briefing talks about this $4 billion delta between what could be captured and what is captured, and that just immediately sends off flags about arbitrage. And I guess I'm just wondering why is it the case that it's because of the lack of the approval of your application that exists? And what would happen the minute, suppose that the application's approved, and would it just immediately collapse? Why does that persist?
So it persists because if we don't have, if the trust doesn't have ETP status, it can't engage in, doesn't have the authority to engage in continuous redemption and withdrawals, which is what would bring the value of the trust into line with the actual value. That's a very substantial problem. So ETP approval would eliminate that impediment. I don't know that means it. I apologize. I probably should know this. I don't know whether we jump immediately.
But it's the redemption mechanism that's the key,
Correct.
and that's preconditioned on
ETP.
approval of the ETP.
That's the key to the whole thing, and that's why I think denying approval does serve investors, and what everyone thinks about investors' interests themselves. It actually does say that one of the SEC's jobs in line 65 is to remove impediments to the market. This is obviously lockup of $4 billion is obviously an impediment.
Make sure my colleagues don't have additional questions for you. Leave you some rebuttal time, Mr. Riley. Thank you.
Thank you.
Ms. Parise.
Thank you, Your Honors. And may it please the Court, Emily True Parisi for the Securities and Exchange Commission. The Commission's order should be upheld because it was the product of reasoned decision-making, reasonably distinguished prior approval of different products, and was faithful to the statutory scheme that Congress enacted in Section 19, which says that the Commission shall disapprove SRO rule proposals where the Commission cannot make a finding of consistency with the Exchange Act. And I want to get right to the point about why it was reasonable for the Commission to treat different cases differently here. It is undisputed that the spot markets in which the assets underlying petitioner's product trade are fragmented and unregulated, in contrast to the situation of the approved futures products, where the underlying assets trade only on the CME, which is regulated by the CFTC, and where the exchange has a surveillance sharing agreement that gives it access to information like market trading activity, customer identification, the tools to investigate a fraud and manipulation if it were to occur.
Ms. Parisi, I understand that those distinctions that the Commission has drawn, but it seems to me that what the Commission really needs to explain is how it understands the relationship between Bitcoin futures and the spot price of Bitcoin. Because it seems to me that these things, one is just essentially a derivative of the other. They move together in 99.9% of the time. So where's the gap in the Commission's view?
So, Your Honor, what the Commission said in its order is that the relationship between the spot and the futures as to the relevant question that matters here, which is, does fraud and manipulation in the spot market affect the CME futures market in the same way? That is an empirical question for which petitioner bears the burden, and they did not show that. And the 99% correlation, what the Commission's order says about that is, it said, one of the things it said was that correlation doesn't equal causation, but it did go much further than that. It says it's just an unsupported empirical leap, and this is a JA 172 and note 223. It's an unsupported empirical leap to go from a correlation of once a day futures prices to any fraud and manipulation in the spot market affects futures in the exact same way. The focus on once a day prices doesn't tell you what's happening to intraday prices. And importantly, it doesn't tell you the causal relationship, it doesn't tell you which direction the relationship is moving. And I think the way you can best see that this is a empirical question that petitioners just try to assume their way past is that in the reply brief at 5 to 6, I take them as making the argument that you articulated, Judge Rao, which is that this is just a future. And so necessarily by the nature of a future, the prices in the futures market will just move to make the spot. But that is 180 degrees, precisely the opposite of the economic proposition that they argued before the Commission, where they argued in the context of the trying to say that they had a surveillance sharing agreement with a significant market, that in fact it's the futures prices that lead the market and that spot will move to meet the futures. And they made that point at JA 187 in the notice and at JA 132 to 133 in the slide deck. So they have argued two opposite economic propositions. They're arguing here that the futures prices will just move to meet the spot. They argue below that the spot will move to meet the futures because futures leads. I think the point is that is an economic question, which they bear the burden of showing the data, and we just don't have the data for that. So
What kind of data would they have to show? I mean, it seems like it's fine for an agency to say, okay, we need some more information, but it seems there's quite a bit of information here on how these markets work together. And the SEC has not offered any explanation of that the petitioners here are wrong in how they're describing the relationship. And the SEC, you can say that they bear the burden, they do, but it seems the SEC has to explain why they are wrong in the evidence that they have proffered.
Well, Your Honor, I think the commission very clearly laid out one way they could meet their burden, and that's at JA 171 to 172 of the order, where they say very explicitly one way that you could meet the commission's concern is if you could show that the spot market price, you could do a lead lag demonstration. You could show that the spot market prices don't lead futures prices. But the showing that petitioners made on that central empirical question was inconclusive, is what the commission found. But they have certainly laid out a path for data that petitioners could present, and they've laid it out clearly. It's just that these Bitcoin futures have only been trading since 2017, and what you look at when you look at the studies that the commission, the economic evidence that the commission considered, there were numerous studies in the record that the commission looked at, and the evidence is just mixed at this point. It's bidirectional sometimes. It depends on what period of time you're looking at. So the fact that they haven't been able to make that showing yet doesn't mean that they won't be able to in the
What
future.
about the fact that the commission in the Tucrium order recognizes that the futures prices are influenced by the spot prices? And the commission concludes in approving the futures ETPs that any fraud on the spot market can be adequately addressed by the fact that the futures market is a regulated one. So, I mean, that's a conclusion that the commission drew just a few months before it denied, the spot Bitcoin ETPs.
I'm not sure that's quite what the commission concluded, Your Honor, in the Tucrium order. If you look at footnote 46, it very clearly says that its reasoning in the order does not extend to spot Bitcoin ETPs. And the reason is because in Tucrium, there was a one-to-one relationship between the underlying market, the futures market, and the regulated market with which the exchange had a surveillance sharing agreement. So what the commission said there is, we can be reasonably confident that surveillance will, if the fraud and manipulation is targeted at at the price of those underlying Bitcoin futures, that the CME surveillance will catch that. So we can reasonably rely on that. But it specifically said in footnote 46, that reasoning does not extend to spot Bitcoin.
I understand that they wanted to reserve that because obviously the commission was looking ahead to these pending orders on the regulation of spot Bitcoin. But that still, they say that, but what's the logic behind it?
Well, the logic is because without, and they go on to say, the key phrase there I think is without additional data, right? Without additional data, we cannot be as confident that surveilling the CME futures market will pick up fraud and manipulation that is directed at spot market.
They say they can't be as confident, but in approving the futures ETPs, the commission seems to be that the commission has to have necessarily drawn the conclusion that this, that this arrangement would prevent fraud and manipulation on the underlying spot market because they recognize the relationship between the two markets and they approve the rule for the futures market. So for the futures product.
Again, I think the theory behind looking for this surveillance sharing agreement with the significant market is it reasonably likely that a person attempting to manipulate the ETP in question is also going to have to trade in that significant market. So for Tucrium, the exchange had the surveillance sharing agreement with the market where the underlying assets themselves trade. So again, the commission says it can be reasonably confident that manipulation aimed at affecting prices of that Tucrium ETP holding CME Bitcoin futures, that would be caught by the surveillance. But without additional data about whether fraud and manipulation in the spot market impacts futures in the same way, that's the missing empirical piece. You cannot make that, you can't have that reasonable confidence when the case here is you have a spot Bitcoin product and they're trying to rely on a proxy market, here the CME futures market, for their surveillance sharing agreement.
So can I ask, does this entire argument then rest on the proposition that both in the Tukriam order and in the order under review, when the commission refers to trading outside of the CME Bitcoin futures market, that means trading outside of the CME Bitcoin future market, but not the spot market?
I'm not sure it has to be, but not the spot market. It's not making any pronouncement one way or the other about the spot market. It's saying wherever the off exchange manipulate, or wherever the off CME manipulation is occurring, if it's targeted at, if it's aimed at the CME Bitcoin futures, then we have a hook, a surveillance hook for the CME Bitcoin future surveillance. So again, it's about the.
But let's suppose that that it at least possibly encompasses, that phraseology at least possibly encompasses the spot, because I think you just said that it might. You don't have to show that it actually excludes it. So let's suppose that it does include the spot market. Then isn't the necessary upshot of what the commission said and did in Tukriam and then repeated in this order that if there's manipulation in the spot market, that's going to show up in the futures market and in CME in particular enough that the surveillance mechanism is going to be able to detect it. And therefore we're okay. Because if that weren't true, then the Tukriam couldn't have been approved.
So what it didn't say that if manipulation in the spot market is occurring, it will show up. It said if manipulation is occurring off the CME, wherever that may be, and it is targeted at CME Bitcoin futures, then the would-be manipulator is reasonably likely to have to trade on the CME and we will catch it. But it's not talking about all the spot market manipulation that may not be targeted at CME Bitcoin futures, because that was not an issue in Tukriam, and that is the question before the court today. And that is an empirical question that the Tukriam order doesn't address, it doesn't answer, and that petitioner submissions have not answered. The relationship from spot market manipulation that is targeted at a underlying spot Bitcoin product, that was not addressed in Tukriam.
But why wouldn't it necessarily, what's the delta? Why isn't it always the case that manipulation of the spot market, regardless of what your aim, I mean, you could aim to want to affect the futures ETP on the CME, you could aim to want to affect something else. It's just going to follow like the night follows the day that it affects both. Because the futures market, of course it turns on the spot market.
Well, again, that the causal relationship between futures and spot is the key empirical question that we don't know the answer to. It may be that spot leads future and that futures follows, but it may be that futures leads spot. And if depending on which one, that's sort of the key empirical question that we don't know. And it's also the focus about the amount of risk is only sort of part of the story. Like whether you can detect and deter fraud manipulation also has to do with where you're looking for it and whether you have the tools to investigate it. And so that's what the surveillance framework is looking for, right? It's you have the tools in place to investigate if a fraud and manipulation occurs. For Tukriam, there was the one-to-one relationship. So the commission is confident that the exchange has the tools in place. They're looking in the right place to catch the fraud and manipulation.
Ms. Percy, if the commission says it's an empirical question about which leads and lags, but they approved the futures product. So don't you have to have a view? Doesn't the commission necessarily have to have a view about the lead and lag? If you don't know, then how could you conclude that the futures product is, that it's sufficient to prevent?
So, Your Honor, what the commission explained is for Tukriam, the exchange had the surveillance sharing agreement with the market where the underlying assets themselves changed. So
but if you don't know which is leading and lagging, I mean, so what if there's surveillance? I mean, if there's all kinds of fraud on the spot market that is leading the futures market, then
Right. So what the commission explained is you don't need the lead lag analysis in that context because the lead lag comes into play where you don't have the one-to-one relationship between the surveillance sharing agreement and the underlying market. Instead, what you have is the case here. You have a surveillance sharing agreement with another proxy market, like a derivative market. And you're trying to say that that surveillance sharing agreement, even though we don't have the one-to-one relationship, is enough. And we can be reasonably sure that our proxy market surveillance will be sufficient. And one way to demonstrate that sufficiency is the lead lag analysis that shows that a would-be manipulator of the ETP in question here, a spot market ETP, would be reasonably likely to trade in this proxy market to manipulate the ETP. So it comes into question when you're using a proxy market like here, you don't need the lead lag analysis for the two preem order because of the one-to-one relation.
This also seems to go to this argument that the commission makes in its brief that it's not concerned, that it's not focused on the actual potential for fraud, only the regulatory detection of fraud. That seems like a very peculiar thing for the commission to be focused on, given the language of the Exchange Act. I mean, can you explain why that is the commission's view, that they're concerned only about regulatory detection of fraud, but not actual fraud?
Well, I'm not sure the commission said they're not concerned about actual. But I think they said their focus was on detection of fraud, and I think it is a reasonable interpretation of the Exchange Act to focus on surveilling for fraud. It is hard to regulate what you cannot see, and so surveillance is the eyes and the ears and it's a deterrent so that the would-be manipulator knows that the exchange has the tools should a fraud and manipulation occur to track it down and investigate it. So the focus on surveillance is certainly a reasonable interpretation of the Exchange Act because that is how you detect fraud and how you deter fraud.
But it's only about surveillance of fraud to the extent that it actually prevents fraud and manipulation, which is the statutory standard.
Correct, Your Honor. The statutory standard is the exchange's rules must be designed to prevent fraud and manipulation.
So if you can see something, okay, that's fine. But if that thing is affected by lots of things you cannot see, I mean, surely the commission needs to be concerned with the things they cannot see.
Certainly, Your Honor. But what the commission has said is there are different ways you could satisfy that statutory language of preventing fraud and manipulation. One way, a tried and true way that the commission has approved for decades, is to focus on surveillance, because we are confident that having a surveillance sharing agreement with a significant market of regulated size will provide adequate surveillance that will serve the purposes of the statute. But that is not, the commission has never said that is the only way to satisfy that statutory language, and it has held out the possibility that other means could also satisfy that language as well.
I have one other question. So if we were to agree with the petitioners here and hold that the commission has to treat these two products, or that they have not treated the like products alike, would the commission look to approve the spot product, or would it go back on its approval of the futures product? I don't know if you can say.
I mean, I can't speak to what I cannot speak to what the commission would do, and I don't want to prejudge what the commission would do. But certainly, if you disagreed with the commission's position here and sent it back, the commission would have to think about the issues anew. But what it would do with the prior orders, I can't speak. But I would like to answer your. But I see my time is up. But you had a question about Chevron deference, Your Honor, that I wanted to briefly touch on. I think it's clear from Net Coalition at 533 that the commission does get Chevron deference here, where Congress has expressly delegated to the commission the power to determine if a proposed rule is consistent with the Exchange Act. The situation was very similar there. It was an order, there was an SRO approval order, but the commission, this court was very clear that the commission gets Chevron deference in those types of situations where it's interpreted.
Does it preserve that argument here? Have you preserved that argument here?
Certainly, Your Honor, the court, the commission consistently applied its interpretation and its orders, and we raised the Chevron issue. We cited Net Coalition in our brief and said that we get Chevron deference. So I don't see that there's been any waiver.
I want to ask you before we stop. You've mentioned several times that they carry the burden of proof. you emphasize that. It's a way to deflect from judge's instinct to say, wait, this was your call. What's your explanation? So tell me, so I have it straight in my head, what data is it that you think they have failed to introduce to make the claim that they're advancing now? Specifically, what is it they have not put into evidence for the commission to be able to consider and rule in their favor?
Sure, Your Honor. I think the commission highlighted this in its order at JA 172 and note 223. But the key empirical question where there's insufficient data for the commission to make its required finding is that the key empirical question is whether fraud and manipulation in the spot market impacts CME futures in the same way. And there's just, we don't have conclusive data.
Say that again, in the same way?
Right. The fraud and manipulation in the spot market would affect futures in the same way so that we can rely on the surveillance of the futures market as a proxy for the underlying ETP spot product at issue here. And one way that applicants have tried to make that showing before is with a lead lag analysis, because if you could show that spot doesn't lead, then you could be reasonably confident that the would-be manipulator of the underlying spot product would be reasonably likely to trade in the futures market. So we could rely on that future CME futures market surveillance. But without that missing empirical piece, we can't be sure we can rely on that CME futures surveillance for a Bitcoin spot product in the same way we could have been, the same way we were when we approved the Bitcoin futures.
What do I glean from the statement in the two-cream order on 21680 that says, in addition, the commission is not persuaded that the market for CME Bitcoin futures contracts stands alone, has a lack of connection with, and is not specifically materially influenced by other Bitcoin markets. That last part talks about a connection in a particular direction.
Yes, Your Honor. And we addressed this in the order in brief, but that was in response to an argument from the applicant in that case that said that there was that the CME market stands alone, and the commission said, well, we're not convinced that we can go that far. But there is a large delta between not convinced it stands alone and futures fraud and manipulation in the spot market impacts CME futures in the same way. There's a wide gulf between those two, and it's that empirical gulf in the middle where there's insufficient data here.
And I have one last question, which is, and this is unrelated to anything we've been talking about so far, and that's just, can you just explain succinctly how the second prong of the test actually furthers the interest? Because the way that the prong is articulated, it indicates that it's bad if there is, if the market that's at issue, the market that's being surveilled, is unduly affected by the product at issue. And to me, it feels like it should be the opposite, because the more that the product at issue affects the market, the more you'd be able to detect manipulation because of.
So I think if I'm understanding Your Honor's question correctly, it's not that the market underlying the spot product, it's the second prong is about trading in the ETP itself. And if it predominates, then there is a concern that the fraud and manipulation could be in that, and that you wouldn't see it in the market that you're surveilling. Because it's not the underlying market, it's trading in the ETP itself. That's the distinction.
But why wouldn't the treaty, if the trading in the ETP itself has a dominant influence in the surveilled market, why wouldn't it show up in the surveilled market?
I think because you could be trading in the ETP itself, and it wouldn't necessarily show up in the futures market if you are trying to manipulate the ETP itself.
Oh, I see. It's the futures of the ETP. Got it. Okay. I see. So the underlying asset is the ETP. It's trading in the ETP itself, and it wouldn't.
It would not necessarily show up. So that's why there's two prongs to the test. I'm understanding Your Honor.
Even if there's a dominant influence, it wouldn't show up?
If it predominates, then there could be trading in the ETP as opposed to we're not, and so you could be trying to manipulate the ETP itself, and it would not necessarily show up in the surveilled market such that we have it. What the significant market test is really about is there this other market for the, here it's futures that is significant and real. So if the trading in the asset itself here, the spot ETP can predominate in that market, then we're not sure if surveilling that other market will capture all the manipulation, because you could just be doing it on the ETP itself.
Okay. Okay, thank you.
Unless this court has any other questions, we would respectfully ask this court to uphold the order and review. Thank you very much.
Thank you, Ms. Parisi. Mr. Verley, we'll give you 3 minutes for rebuttal.
Thank you, Your Honor. A few points. First of all, with respect to the description of the analysis in Tucrium versus here, my friend from the SEC said that the point of Tucrium was to find fraud that was targeted at manipulating the CME futures market. Again, the Tucrium order speaks for itself. One can read it. It doesn't say anything like it. It's all about whether fraud and manipulation on other unregulated markets will affect the price, not whether it's a scheme to manipulate some other unregulated market in order to manipulate the CME futures market. And that stands to reason, because we're trying to protect investors from fraud and manipulation. And if there's a fraud and manipulation in an unregulated market and it affects the regulated market, why does it matter whether it's targeted as the same adverse investors? So you just won't see that there. And that gets to the point that my friend was trying to draw this distinction between the one-to-one relationship and proxies. But the whole analysis in Tucrium was about proxies. All these unregulated Bitcoin futures markets, as well as the spot markets. And the issue being addressed was whether fraud and manipulation in those unregulated and therefore unsurveilled markets would have an effect. That was the essence of it. Now, my friend says we made a 180 in our arguments about the relationships between the CME futures market and the spot market. A little context here. Tucrium order came out while the commission was considering our order. If one reads footnote 46, which my friend referred to, you'll see that basically it says, bring us the broomstick of the wicked witch of the West. There's one and only one way we'll let you in, and that's if you prove that CME futures leads spot. So we tried. But we also argued in the alternative all of the points that we're making. Nothing inconsistent here. That's what anyone would do in that situation. And it does get to the point, I submit, that this focus on lead lag is really a red. Because if one takes a step back, there are really three possibilities. Lead lag, if a market leads, it means that's where the price is set. And then the other market follows. So if the futures market is leading the spot market, then the surveillance here is going to pick up any fraud or manipulation because the surveillance is of the futures. If the spot market is leading the futures market, the surveillance is going to pick it up because the effects will show up for all the reasons that we talked about earlier. And if it's a arrow points both ways kind of situation where there isn't one consistent leader and one consistent lagger, same point. It's going to be picked up when it shows up. And I do think, getting to Judge Edwards, your question about what the data is, we already put the data in. It's the 99.9% correlation. It's the comments from experts in the field. That's in there. And part of the reason that we submit that this is an unreasoned order is that they just kind of went like this. They just shrugged it down. They said, well, it's not enough. But they didn't say why it is. In the face of, and that evidence is unrebutted. Nobody came in and said anything else. See, they have to explain why that is enough to satisfy decision making. Shrug doesn't put you there. And then let me just make sure I've got everything covered here. I think that's just one final point. But, they say that in that footnote 46 of the Tucrium order, they say, and twice in this order, they say, there's reason to question whether the surveillance, CME surveillance, will pick up the spot. They never actually say why there's a reason to question. And that's the whole problem, given what they said. They can't just say, well, maybe it'll be in the face of arguments. They've got to explain why it's different. And they've completely failed to do that. Reason,
I have one question that is on just in the body of the order near this footnote 46, on the question of whether the order is predicated around the idea that it's all about whether there's targeting as opposed to just an effect, whether there's targeting. The way the commission framed it is thus the CME's surveillance can reasonably be relied upon to capture the effects on the CME Bitcoin futures market caused by a person attempting to manipulate the proposed futures ETP. So it does.
In that sense, certainly, but that's a subset of what it catches. It's not the sum total of what it catches, and it can't be because this has come up repeatedly in the court's questioning. But in order to have approved the futures, you have to have decided that the statutory standard was met, which is that it prevents fraud and abuse. That the rules of the exchange are designed to prevent fraud and manipulation that will affect the product that's being applied for. And that's why I said the intent, the target, doesn't matter if you could show that there is fraud or manipulation and it would affect the underlying asset, and it isn't provided. There's nothing in the design of the exchange that protects against it. You can't satisfy the statutory standard, but they found the statutory standard satisfied. That's the key. Found it satisfied. That's what I think their targeting argument doesn't really get. Oh, and I'm sorry, and I did have one point about the second prong, because Your Honor raised it, if you don't mind focusing on that. I think Your Honor was getting at something. I mean, there are some points we made in our brief about the consistency with Kukrium on that, et cetera. But there's a basic point here. It's another one of the contradictions in this order, if you think about it, and I think Your Honor's questions were getting at it. They say, on the one hand, that we haven't shown that made a sufficient record that that fraud manipulation that occurs in the Bitcoin spot market will show up. On the other hand, they're saying there's an undue risk that the Bitcoin spot market, that our ETP or Bitcoin spot will have such a powerful effect,
a predominant effect
on the price of the CME futures market that we won't be able to discern. We can't say both of those things the same. Thank you.
Thank you, counsel. Thank you to both counsel. We'll take this case under submission.
Following these arguments, the court affirmed the district court's decision, finding that the indictment in this case does not state an offense. What do you think about this case? Let me know in the comments below. And if you like this video, hit subscribe for more arguments every week.